So there was a mega deal that happened about 8 or 9 years ago, talking about the MAC provision. So material adverse change, right? If something, I'm not a lawyer, I'm not giving legal advice, but if something giant outside the control of most parties happens during the close window, the buyer has the option to exit a deal. I was involved in a transaction where the MAC clause was triggered. Ultimately, it went to court, and it was extraordinarily contentious. And this was during the great financial crisis. But ultimately, the court system, luckily we live in we have 3 branches of government, and the judicial branch is one of them. And why people want to be doing business in the United States, because the rule of law is what controls, is that ultimately this went to this Third Circuit court in this case. And ultimately the judge said, no, like the great financial crisis and in totality was an exogenous event, but it is not a catalyst in terms of the MAC provision in this particular transaction. So when we talk about why does that matter? Being right in the middle of that was fascinating, and just because it was hitting in the Wall Street Journal and CNBC, and I was right in the middle of it. It was pretty cool. But why we were talking about concepts of wargaming, and how are these low likelihood, high impact events going to be coming around the corner, and how do you remain agile and resilient to be able to grapple with them as a company, let alone during an M&A transaction or event, is critical, right? As you think about companies being able to drive shareholder value and reduce risk. So that's one of the craziest that we can tell on video, deals that I've been a part of. Over drinks is a different conversation, my friend.
That's crazy.